matter, an application for an enterprise agreement, for the approval of an enterprise agreement was lodged by DP World in relation to two different enterprise agreements. The applications were lodged and included, as is required, a statutory declaration on behalf of the employer. In the statutory declaration, an error was made which stated that 332 votes were cast against the agreement and 25 votes were cast for the agreement. In the second agreement, it was stated that 96 votes were cast against the agreement and 2 for the agreement. This was incorrect, and the voting, in fact, had been the reverse. Application was made by the company that in any event, due to this clerical error, the Commission should approve the agreement. Commissioner Cambridge said he was not going to approve the agreements. There was no material before him on which he could approve the agreements because the material before him, the statutory declaration, indicated the agreement had not been made by a valid majority of employees. He also noted that there were some deficiencies with the notice of employee representative rights, which could in any event have invalidated the bargaining process. Due to the incorrect statutory declarations, he didn't have to make a finding in relation to that.
So it's really important in terms of notices of employee representational rights that the form that's set out in the Fair Work regulations is strictly adhered to. If there are changes, things added into this document that shouldn't be there, the Commission has a right to reject the agreement being approved. And there was, as well as the comments in relation to this case, there was another enterprise agreement, Neil Sealing's enterprise agreement, that was rejected by the Commission on the basis that they had added in information to the notice that shouldn't have been there. So whilst there are a few key things that have to be added in by employees, such as the name of the enterprise agreement, who will be covered, the Fair Work information phone number in case people want to call and ask questions, then nothing else should be added in because it really could stuff up the whole process in terms of approval.
And look, the terms of the notice of representational rights is a little bit, how should we say, unappealing in some cases. And it often comes up that, an employer will say to us, can't we just amend this? This is very clinical. And the answer is no, you can't amend it. Yes, you can send something separate out with more of the touchy-feely stuff, but don't change the notice of representational rights. They need to send the notice.
And the other important thing is that the notice needs to be provided at least 21 days before the agreement goes to a vote. So if that issue is missed as well and the timing is wrong, again, an agreement can't be approved, and the Fair Work Commission will look at it very carefully.
And it is also really important to note that the Fair Work Act sets out very clear procedures that must be followed. So, for example, an agreement must be filed with the Fair Work Commission within 14 days after it is voted and passed by the majority of the employees. And also in this, whilst it was clear that there was an obvious clerical error in that the person that signed off on the statutory declaration obviously put the wrong numbers in, it does call into question the validity and all the other information that's in the statutory declaration. So it is important that everything in there is right and that it's double checked and correct.
I mean, a statutory declaration, it has to be remembered, like an affidavit, is something where the person executing it is verifying on, pain of possible criminal sanction that it is correct. Before the Fair Work Act came into play, there used to be compulsory hearings in relation to enterprise agreements, and that's been removed. And there's been reliance, in most cases, just on the paperwork. But given that it is paperwork that is taken very seriously by the Fair Work Commission, and clearly whoever has signed and executed, well, in this case, poor Miss Quintrell, whoever prepared the agreement, she signed it, and she clearly didn't read it in the way you should read a statutory declaration to make sure everything was correct, which is very carefully.
And the problem, I guess, with the particular statutory declaration that we're referring to is it's quite lengthy in nature and quite complicated. So it really needs to be probably carefully checked by a few people to ensure that everything in there is right, because there are so many different questions that need to be gone through statistics provided, including on the vote, the characteristics of the employees, etc.
But it absolutely has to be checked, but it also, the person who's signing it has to understand it. They can't just rely on someone else because they're the one making the declaration, and if they don't understand it, they should ask questions.